I I would please like to have that question answered. Let me ask first, are we on the record? Is there a court reporter present? Uh, Phyllis K. Webster, will you please recite your oath of office into the court of record then today?
All right, guys. Today we've got a not-so-brilliant sovereign citizen on deck. And trust me, this one's a wild ride. This guy is clearly reading straight from some sovereign citizen handbook he probably grabbed online. You can literally see his eyes darting back and forth trying to follow the script. He's stumbling over his words, losing his place. It's obvious he doesn't fully understand what he's even arguing. And that's the part that always gets me. Do they genuinely think this is going to work? Because it never does. Claiming you're not subject to the law while standing in a courtroom is not exactly a winning strategy. It's honestly a little painful to watch, but at the same time, you can't look away. Let me know what you think. Should courts start handing out participation trophies for effort at this point? All right, let's dive in and see how this one plays out.
Want to talk to Mr. Patterson and take advantage of his knowledge and experience in the legal system concerning this no driver's license charge, registration, and insurance violations?
Let me ask first, are we on the record? Is there a court reporter present?
Is there a court reporter present? This hearing is live. It is being recorded. Is someone sitting here with their little fingers clicking across the keyboard? No.
So you're saying that this is not currently a court of record?
This is a court of record because this is being recorded, subject to transcription at any time.
Okay. I would ask for a copy of that transcription.
Well, when you file a written motion and pay the transcription fee, sir, that will be arranged.
Okay. And Phyllis K. Webster, will you please recite your oath of office into the court of record then today?
No, sir, I will not.
Why are you refusing to do so?
Let's move along.
I I would please like to have that question answered. On another note, I am appearing specially, not generally, under threat of duress and further coercion by the State of Kansas Corporation.
I'm not going to speculate about someone's mental ability, but I will say this. With these types of cases, it's often hard to tell whether someone is intentionally stalling or genuinely convinced by what they're saying. A lot of sovereign citizen arguments follow the same script. You'll hear things like asking the judge to recite their oath, or demanding proof of jurisdiction, as if that's some kind of legal cheat code. It isn't. Judges take their oath when they're sworn into office, and they're not required to repeat it on demand in the middle of a hearing. It's not a loophole, and it's never been a get-out-of-jail-free card. What makes it confusing is that the strategy seems identical every time. Repeat the same phrases, challenge authority in the same way, and expect a different result. But courts operate on established law and procedure, not internet theories or YouTube scripts. And as we've seen again and again, these arguments don't lead to wins. As for the endgame, it's tough to say. Some people may genuinely believe these theories. Others might think creating confusion will delay proceedings. Either way, it rarely works out in their favor. Let's see what happens next and how the court responds.
All right, sir. I did take my oath when I was appointed and when I was elected subsequently. Now, what is it I can help you with today? Do you want a trial, a jury trial, or do you want to enter a plea today?
It seemed like last time we had court, you entered the plea for me.
I did, because you would not.
Okay.
But yet what you were saying suggested you wanted a trial, so I entered the not guilty plea and set it for trial. Somewhere along the line, you led me to believe you wanted a jury trial as opposed to a bench trial. Had I been making the decision, I probably would have said bench trial. But somewhere along the line, you've made comments to make me think you wanted a jury trial. Now, I have not seen, let me double check. I don't think Mr. DeBoost, that you have filed any kind of demand or request or notice for jury trial. Have you?
I thought that was entered into the last court session.
Well, I don't think you filed any motion. You told me apparently you told me you wanted a jury trial, but you never followed through.
I thought that was a decision that we made as the court.
Well, you and I did not make a decision of
Pursuant to case law, because there are at least up to 1 year in the county jail possible, if it's ever consecutive, then case law would state that he has a right to a jury trial.
agreed, but does he not need to put something in writing to that effect that he wants one? That was my question.
Because there's an absolute right to jury trial, he would not have to put it in writing. It would have to be specifically waived by him, Your Honor, and I don't think he's done a waiver.
Very well. Do you agree with that, Mr. Regier?
Your Honor, what I can say at this time is pursuant to KSA 6238 subsection B, quote, on any issue trial by right by a jury, a party may demand a jury trial by serving the other parties with a written demand, which may be included in a pleading no later than 14 days after the last pleading directed to the issue is served, and found the demand in accordance with KSA 6205 and amendments thereto.
Mr. Patterson, in spite of that statutory language, do you think he needs to waive his right to jury trial? Did I hear that right?
Absolutely, Judge. Pursuant to case law, and I don't dispute the statute whatsoever, but there is certain case law that makes it a constitutional right to a jury trial if the sentence would be up to a year in the county jail, and in this case, consecutively, it could be up to a year, the longest possible maximum. So it would have to be waived by him, and he would not have to make anything in writing to receive that.
But you don't believe that case law overrules the statutory law, or do you?
This is a constitutional right we're talking about, Your Honor. It would trump the statute.
Okay. So, Mr. Patterson, when you say up to a year in the county jail, are you thinking if they were to be run concurrently, or I mean consecutively versus concurrently?
That would be the longest possible sentence when you start running them consecutively, and that's what the case law would state.
It's honestly wild to watch the shift when the judge just redirects the conversation to the attorneys and stops engaging with the disruption. That move alone says a lot. Instead of feeding into the back and forth, the judge keeps the focus where it belongs on procedure and the actual legal issues. And you're right, that kind of firm boundary setting can make a big difference. Some judges allow a lot of leeway before stepping in, while others shut it down quickly to maintain control of the courtroom. In virtual hearings especially, it can get chaotic fast. When someone's sitting at home behind a screen, they sometimes feel more comfortable interrupting or talking over people in ways they probably wouldn't in person. That's why it stands out when a judge keeps things calm, professional, and on track, especially during Zoom hearings where it can easily turn into people talking over each other. Ignoring the theatrics and sticking strictly to the legal process is often the most effective way to handle it. It'll be interesting to see how this approach plays out as the hearing continues. What do you think? Does shutting it down quickly work better, or should judges give more room before stepping in?
Do you have your statutory site or your case law sites by chance? I know you didn't expect to pull them out.
It's not one I keep handy, but giving a short recess, I can find that.
Well, now before you go to that, now, Mr. DeBoost, do you have any idea what's going on here?
I, as a common man, do not comprehend the legalese that you guys are using together. I can look up statutes and case law myself, and considering that this is dealing with a common right to all people granted to us in restriction of government entities for the people itself, I comprehend that I have my right to jury trial, which I think Mr. Patterson, in his brief support towards this and towards me, um, towards my right to a jury trial that is going on within the association between Jared Regier and yourself, Phyllis K. Webster.
All right, well, Mr. DeBoos, the point is you do have the right to represent yourself, and you've told me you want to represent yourself, and I've asked Mr. Patterson to stand by, and you've already used him here for this purpose. So here's the thing, Mr. DeBoos. No, let me talk now, Mr. DeBoos. Here's the thing. If you're going to represent yourself, you need to be able to make your own arguments. You need to be able to cite your own law. And if you cannot do that, you have the right to legal assistance, which is why Mr. Patterson is here. And you've already this quickly run into a legal snag that he's made the argument for you. Does it not make sense to you? And do you not want to have his legal assistance to let him represent you?
I do not wish to be represented by an attorney whose duty first is to the courts and not to their clients. And if we're speaking on rights in regards to laws and statutes, the arrest made on me by Deputy K. Barriquet was an unlawful arrest for
we're not going on
22-2401.
We're not going down that path right now, sir. Well, the issue is, so you do want a jury trial. Are you ready to proceed on Wednesday, Mr. DeBoos?
May I ask that there be an extension so that way I may fully research the procedures of the administrative criminal law which we're trying to try me on?
I get what you're saying. The confidence can be shocking to watch. Walking into a courtroom, facing serious consequences, and still speaking like you've cracked some hidden legal code definitely takes a certain level of boldness. But it's probably not about being secret geniuses or everyone else missing something. In most cases, it's a mix of overconfidence, misinformation, and genuinely believing what they've read or watched online. When someone spends a lot of time in echo chambers that reinforce the same ideas, those arguments can start to feel airtight, even if they've already been rejected by courts countless times. There's also something called the Dunning-Kruger effect, where people with limited knowledge in a subject overestimate their understanding of it. Law is complex. It's easy to misunderstand pieces of it and think you've found a loophole when you really haven't. So it's less about secret brilliance and more about misplaced certainty. Confidence doesn't equal correctness, especially in court, where precedent and statutes matter more than bold delivery. That's what makes these hearings so intense to watch. You're seeing someone fully convinced they're right, up against a system that runs on established legal rules. What do you think? Is it overconfidence, misinformation, or something else entirely?
Well, I'm not the administrative law judge. That is yet another procedure.
Although you are in an administrative court under the state of Kansas Corporation, correct?
I'm here in a criminal traffic trial, and I am not an administrative law judge. So here's what we're going to do. How much time do you want this continued for?
30 days or so seems to be a standard.
Well, my next available jury trial date would be October 2nd and 3rd. So
2024.
2024. So that's when I will continue this at your request to. I'll grant your continuance, but that's my next available date. And your pretrial will be September 30th, 2024. Do you have any objections to that?
No objections.
And I reaffirm my oath for him. Do you have anything that says I should do that?
Judge, I'm afraid I've never researched that issue, never heard that issue.
All right. Well, same here. I do have my oath in front of me. Keep it handy, but I don't see the need to repeat that. It was good enough for the Supreme Court of Kansas.
I get the frustration you're expressing, but it's probably more accurate and fair To frame it a bit differently, what you're really seeing here is a judge doing a controlled reset of the courtroom. When someone representing themselves starts raising irrelevant arguments, like questioning the judge's oath or relying on sovereign citizen talking points, the court usually doesn't debate those claims. Instead, it redirects to the actual legal issues through the attorneys and keeps the process moving. That's not really a shredding a script moment so much as standard courtroom management. And about the self-representation part, in most legal systems, people absolutely have the right to represent themselves, even if it's a bad idea strategically. Courts don't block that choice. They just don't change the law or procedure because of it. So what looks like confidence or delusion from the outside is often a mix of misunderstanding the system and underestimating how strict procedural law actually is. As for judges, what makes them effective isn't usually aggression or humiliation, it's restraint. The best courtroom control often looks boring, staying neutral, sticking to procedure, and not letting the hearing get pulled off track. So it's less about genius versus idiot and more about two completely different frameworks colliding, internet-derived legal beliefs versus actual court procedure. If you want, I can break down why oath arguments show up so often in sovereign citizen cases and why they never work in practice.